Welcome back to the Constitutional Clarion. When I started out as a constitutional lawyer, I deliberately spurned doing any work on the 1975 dismissal of the Whitlam government. As far as I was concerned, it had been done to death. Too many people had picked over the entrails, and I was much better off exploring the many areas of constitutional law that few people had ever considered. But over time, I began to realise how little was understood about the history of the exercise of viceregal powers, and how a lot of what happened in 1975 was shrouded in constitutional confusion. That confusion engulfed the participants, those who reported on it, academics, and the public at large. So, as the 50th anniversary of the Whitlam dismissal looms, and no doubt an awful lot of rubbish will again be written about it, I thought I'd do a series of videos explaining what happened and what didn't in its constitutional context. And I promise you that whether you're a judge or a politician, an expert, or just an interested member of the public, you will discover quite a lot of things from these videos that you didn't know before. And I hope you'll find them quite interesting. This introductory video, however, is just about why. Why was there, and why does there continue to be, so much confusion about what the fundamental constitutional rules were, how they should operate, and what the consequences were? There are a number of connecting problems here. The first is that constitutional crises involving viceregal reserve powers, while they probably happen more than you think, are still relatively rare. When they do arise, those involved have probably never dealt with a crisis like that before, so there's very little experience to draw on. Now, this is true for viceregal officers, public servants, solicitors general, lawyers, and judges. In fact, it's always fascinated me that governors general and governors would turn to judges for advice about their reserve powers. Frankly, most judges wouldn't have a clue because this doesn't fall within their area of legal practice when they were a barrister, before they went to the bench, or indeed their experience adjudicating legal disputes. In the past, people like Sir Samuel Griffith, who, before he was Chief Justice of the High Court, had been Premier and Lieutenant Governor and a drafter of the Commonwealth Constitution, would have been able to give valuable advice on what was intended. That's probably why he was so often called upon for advice. But that kind of expertise is long gone. So, what does a viceregal officer, a solicitor general, judge, or public servant do when asked for advice upon the scope and operation of the reserve powers? Well, they do the obvious. They turn to look at the books to provide examples of when it's happened and analysis. In 1975, if you turn to your bookshelf, there actually wasn't a lot of choice. There were really only books by Arthur Berriedale Keith, and indeed there were a lot of those, and here's a photo of the ones on my bookshelf in the room next door, which were about the operation of the Constitution in the Empire from a British perspective, and also a book by an Australian, H.V. Evatt. Now, both had their problems. Keith was a Scot who originally worked for the British Colonial Office from 1901 to 1914. He then became an academic, writing numerous books on the operation of the Constitution in the British colonies and the Empire. Keith started with good practical inside knowledge of how the British government instructed its viceregal officers in dealing with constitutional controversies in the colonies, including Australia. His books are a treasure trove of comparative examples across the length and breadth of the British Empire. But Keith approached his subject from a very politically conservative point of view, and his mindset remained stuck in that pre-World War I world of colonies and empire. His analysis of the constitutional relationship between Britain and what became known as the Dominions became less accurate and more distorted over time as he failed to accept the divisibility of the crown, and the changes that resulted from imperial conferences and culminated in the Statute of Westminster. If you remember the video I did about some advice the Chief Justice of the High Court of Australia, Sir Samuel Griffith, provided to the Governor-General in 1916 about the scope of the Governor-General's discretionary powers, this was a reaction against a book by Keith. Griffith was explaining why Keith was wrong about the scope of the powers of the Governor-General. Once Keith became an academic, he also lost access to internal government files. So he had to rely on press reports and correspondence with people overseas to get his information. It was therefore not always accurate. Keith's books are therefore a good starting point to identify various constitutional crises that had occurred, but they were not necessarily accurate in either facts or analysis. H.V. Evatt was so enraged by Keith's books that he actually wrote his own in response. Evatt, for my overseas viewers, was initially a Labor politician in the New South Wales Parliament who was then appointed to the High Court of Australia in 1930 at the very early age of 36. He served for 10 years on the court, but then resigned to go into federal politics. He served as Federal Attorney General and Minister for External Affairs, and later became President of the United Nations General Assembly. He became the leader of the opposition in Australia in the federal parliament, but never became Prime Minister. In 1936, while serving as a Justice of the High Court of Australia, Evatt published his book, The King and His Dominion Governors, and its subtitle is A Study of the Reserved Powers of the Crown in Great Britain and the Dominions. Again, it's a very useful book on various crises that occurred. But Evatt too did not have access to the relevant primary documents, so some of what he wrote is not factually accurate. His analysis is also coloured by his strong political views, which were the antithesis of the strong Tory views of Keith. Now, coming back to 1975, when faced with questions about a crisis involving the deferral of the passage of supply and whether a government should be permitted to continue to govern without supply, the only sources that a person could turn to were really Keith's books, the most recent of which was published in 1938, and Evatt's book from 1936, and maybe also the book by the Canadian Eugene Fawsey on the royal power of dissolution in the British Commonwealth, which is a bit more confined in its subject matter to dissolution and was published in 1943. For anyone wanting to buy copies of these books, the Fawsey and Evatt books were actually republished together in a book called Evatt and Fawsey on the Reserved Powers. So you might be able to pick that up in a second-hand bookstore as well. Now, why was the age of these books a problem? Well, as will be shown in this series of videos, many of the most pertinent precedents concerning the blocking of supply and the dismissal of governments occurred in Australia in the 1940s and 1950s, after these books were written. Moreover, they also happened at the state level. This meant that the relevant documents, which showed what really happened, were not held by the Commonwealth. The only publicly accessible information about what occurred would have been from newspaper reports, which were probably far from accurate anyway. During the 1975 crisis, frankly, no one had time to go to the library and search through old newspapers to explore relevant precedents, even if they had remembered that those things had occurred. Hence, if you look at the legal advices that were provided in 1975, they do not refer to the most relevant Australian precedents. At best, they make reference to books that were written before the Statute of Westminster was even adopted by Australia, when we lived in a different constitutional period as a colony of the United Kingdom. But mostly they rely on British books about the role and powers of the monarch, which are not the same as the powers of the Governor-General under an entrenched federal constitution. The Solicitor General in 1975, Maurice Byers, for example, relied upon Evatt, and Forsey, as well as the British works of Jennings on cabinet government in the United Kingdom and Todd, back from 1893, on parliamentary government in the British colonies. He referred to the Victorian precedent, where supply was blocked in 1877, which I'll talk about next time, but nothing at all about what had happened in Victoria in the 1930s, 1940s and 1950s, also covered in a later video. Thus, you see, for example, the somewhat bizarre assertions by Gough Whitlam that the Governor-General had no power to dismiss him because the Queen's power to dismiss governments in the United Kingdom had faded away. Now, this is wrong on both counts. First, the monarch's reserve powers, which are intended only to be exercised in extremis, do not cease to exist because there hasn't been cause for their exercise in recent times. They operate effectively behind the scenes because they deter ministers from acting in a manner that would warrant their dismissal. They remain live and real. Second, the monarch has no power with respect to the appointment and dismissal of Australian ministers. Section 64 of the Commonwealth Constitution says that the Governor-General may appoint ministers and that they hold office during the pleasure of the Governor-General. This means that the Governor-General has the power to appoint and dismiss ministers, including the Prime Minister. It's express on the face of the Constitution. To suggest the power does not exist, as some have done, is just nonsense. But coming back to the sources that explain the scope and exercise of these powers, why were there no recent and relevant books on these matters? The problem is that most of what occurs during such crises happens behind closed doors under stipulations of confidence. Those who are involved, including public servants, are not permitted to speak or write of what occurred. To the extent that such matters are documented, they are not released for a very long time. Anything concerning the monarch and the palace is particularly hard to get access to. You'll be aware of the hard-fought litigation to get access to the letters between the Governor-General and the palace about the Whitlam dismissal. For many decades, access was denied on the ground that they were somehow private property, not government documents, despite the fact that they'd been written in an official capacity and were being held by the National Archives. In the United Kingdom, legislation was enacted in the year 2010 so that there is an absolute FOI exemption on information if it relates to communications with the sovereign and the next two persons in line to the throne and any member of the royal household acting on their behalf, such as the sovereign's private secretary. That exemption extends for the life of the relevant member of the royal family, plus 5 years, and any document that is ever released has to be at least 20 years old. The consequence of this is that all UK government files in the archives that were created after 1952 have been gutted of any references to the monarch, preventing scholars from getting an accurate picture of Queen Elizabeth II's role in relation to various constitutional crises in her realms around the world. Nothing will be accessible until at least September 2027, and even then it will probably take a long time to apply to get redactions removed from files or indeed documents reinserted back into them. The greatest repository of information about the exercise of the reserve powers is the Royal Archives in Windsor. It applies a rule that no access is given to the documents of a living monarch, so nothing has been available on events that have happened since 1952. The volume of documents from Queen Elizabeth's reign is apparently so great that it will take many years for them to be transferred, assessed and catalogued by the Royal Archives, meaning that the long wait for knowledge continues. Heaven knows I have asked for access and I've been told that they have no idea when the documents will be ready for scholars to see. This means that we are so far 73 years behind in our knowledge of how the monarchy operates in relation to Australia and about the exercise of reserve powers generally. We are unlikely to be enlightened about it anytime soon. This makes it extremely difficult to publish an accurate book in relation to the exercise of the reserve powers, and it discourages scholars from engaging in the field. In addition, because such matters rarely arise, books about reserve powers are not really commercially attractive to publishers. A book on tax or commercial law will sell many copies because people need it to deal with actual disputes in the courts. But who really needs a book on the exercise of reserve powers? Yes, it will be held in the bookcase of every government house and every parliamentary library, but beyond that, it doesn't have a huge market. The upshot is that even those who practice in the field of constitutional law, or write about it, don't focus on the reserve powers of vice-regal officers because the occasions for the exercise of those powers are rare and the accessible material about their exercise is virtually non-existent. If you listen to the recordings of the live radio broadcast on the afternoon of the 11th of November 1975, you will find a professor of constitutional law, Colin Howard, saying that it was utterly unprecedented. But it wasn't. There were several precedents from his home state of Victoria, but he probably just didn't know about them. Even if he'd remembered what had happened in Victoria, he wouldn't have had access to the governor's files, which I have since been able to read. And those files tell us how premiers were forced to resign, i.e. dismissed, because they could not secure the passage of supply. The precedents were there, but the public just didn't know about them, not even the constitutional experts. So these kinds of assertions by experts in constitutional law affected media reporting, leading to all sorts of misinformation being passed on to the general public. Many of the most passionate arguments about the dismissal are based on complete misunderstandings of how Australian constitutions at the state and federal level had indeed operated for decades and ignorance of relevant precedents. Those actions which were regarded as extraordinary and unprecedented were only so to people who had no idea of the precedents and the constitutional history. And this is why we got to a place where there is so much disagreement and confusion on the subject. Do we have a modern book on the reserve powers and these precedents today? Well, I'm glad you asked, because I'm one of the extremely rare people who did do work on this and spent many years trawling through archives around Australia and the world, and did manage to convince a publisher, Cambridge University Press, to publish it. So here it is, The Veiled Sceptre, Reserve Powers of Heads of State in Westminster Systems, published in 2018. I was also very fortunate in being able to squirrel out a lot of material from British archival documents before the law was changed in 2010, preventing access to that material. For anyone interested in adorning their bookshelf with this hefty but rather pretty tome, I can tell you that while the hardback copy is quite expensive, around $300, you can get a paperback version for about $70 and a Kindle version from Amazon for $57, which is an absolute bargain, in my view, given the enormous amount of work that actually went into it. In any case, you can also watch these videos for free as I work through all the different elements of the crisis that culminated in the Whitlam dismissal. There are fascinating aspects of it which are neglected by those with a political barrow to push for either side. So do join me for the ride, and hopefully it will help you to be more informed so that you can make your own assessment of the rights and wrongs of what actually occurred. Thank you for watching the Constitutional Clarion, and join me next time for a continuation of this series. Goodbye.